Hey everybody, it's Dan Morey with Staffing Monthly. Welcome back to this issue where we are digging into some of the compliance concerns that might have an impact on your agency that some of you may or seemingly may not be aware of, but you need to be, because there's some things that have been changing recently that if you do not pay attention to it or take it seriously, it could have major negative implications on your business. And one of those that I want to dig into today with one of my favorite legal writers, Bill Josey, is about the recent I-9 changes where we're kind of going back to the way that we used to have to do it. So we can't just review things electronically anymore. Major change. We all kind of got used to doing it the easy way, which we all feel is a little bit more convenient. But that's going away. And we need to talk about why, what's happening, and what you need to do about it. But before I do, I want to introduce you to Bill Josey, who is the producer of my favorite staffing legal newsletter. It's actually called staffinglegalnews.com. If you don't have a subscription to this, it is worth its weight in gold. It is regular content that's relevant to our industry. Every article is like a 3-minute read. So it is like the perfect pairing with your morning cup of coffee or tea. But Bill is a staffing lawyer. He's actually one of the leading staffing lawyers, and he has been general counsel for some of the big ones like K-Force, Lucas Group. So he's been around the block. He's seen it. He advises staffing corporations about how to navigate the tricky legal landscape that's out there that we're all unfortunately too familiar with. But without further ado, Bill, thank you for being here and contributing to Staffing Monthly today.
Hey, thanks, Dan. It's a pleasure to be here.
So obviously you and I met a few months ago, and you introduced me to Staffing Legal News, and it has been, I'm not even saying this just because I'm interviewing you today. It is legitimately my favorite legal newsletter. And I know it's not always like legal news is not always the easiest thing to write about, especially when I see the legal briefs and the change of the laws. It's kind of dry. The reason that I like yours and I appreciate what you do is they're quick reads. Like you kind of get to the point, you add a personality to it, which I so appreciate. And you also make it relevant as to like what agencies should be thinking about with the implications of the changing law or court cases, and you are really aware of everything that's going on in the industry. So I just want to say thank you for sharing all that information the way that you do.
Appreciate it, Dan. I have a passion for trying to keep people out of trouble rather than helping them while they're in trouble. It's usually more cost effective not to get in trouble in the first place. And I thought about it for a long, long time. There's kind of a gap in the legal information available. The law firms certainly provide a lot of it, but it's not terribly focused on staffing, and it's also fairly academic. The trade groups do a good job of hitting the big picture, but that, again, doesn't always drill down into the day-to-day. And I'm kind of a day-to-day guy. I like to say I'm a staffified lawyer. I get to the bottom line, and I try to get there fast.
It's true. And you do that with these 3-minute reads. And the one that really sparked my curiosity that I want to dig into today was the one that you actually put out on just a few weeks ago. June 26th was the date of it. And it was about a lot of the questions that you've been getting from staffing agencies about the recent changes to the I-9 and how we're basically the electronic remote viewing is ending. And obviously you said you like to keep people out of trouble. I-9s is an area where staffing agencies can get in trouble. And if they do, it becomes very costly because it's per occurrence of issues. So just really quickly catch us up to speed. What's changing with this electronic remote viewing ending? Like what's going on here?
Well, one of the few positive things that came out of COVID was the ability to do remote review of the documents of your new hires. And this has always been a problem in staffing, and it's particularly problematic these days with remote workers. And COVID just blew that up. And so the USCIS said, we're not going to expose people to more COVID by doing face-to-face document exams. You can do it over video. And that's what's been happening. Unfortunately, the law does not allow them to say, and that's good forever. The way the law is written, there has to be a face-to-face sooner or later. And so it is now that the national emergency is over, it's time to pay the piper. And that means that USCIS has announced that effective July 31st, I'll get to August 30 in a minute. July 31st, we must all start doing the face-to-face document reviews that have historically been required for I-9s. And frankly, you should already be doing it, because if you didn't do it effective August 30th, you are going to have to be able to prove that you went back for your existing employees and did a face-to-face and annotate and amend your existing I-9s. Fortunately, it's just for existing employees that you have to do this. For terminated employees, you do have to annotate the I-9 form that to note that they are terminated and you cannot do it face-to-face.
So let's dig into that one, because that's big. So just let me clarify to make sure I heard right. So as of July 31st, the remote viewing is ending. And after that date, you 100% have to be doing in-person review of documents. So that's a key date, July 31st. And then you mentioned August 30th is kind of the deadline where you have to prove that you've done your look back. So they're giving you a month to actually catch up your work and do the in-person document review for all of your existing employees. So let me just throw a scenario out there, Bill, because that seems like it's a huge lift. If you're a staffing agency, and I'm going to pick middle market. Let's say you've got 1,000 existing employees on your payroll that have been with you for anywhere from a week to 2 years. And every single one of them was reviewed remotely. Well, I'll say everyone has been reviewed. Well, just for the sake of ease, everyone's been reviewed remotely. The agency is going to have to go back and physically review face-to-face with all of those employees and notate that on the I-9 that's been done by August 30th.
That is correct.
Ouch. Well, no one's ever going to consider you the bearer of good news. Okay.
No, it doesn't happen.
What happens if they can't do it? Are there penalties that have been stated yet? Or like if an agency can't be compliant with that, because 1,000 headcount, there's agencies that are way bigger than that are going to have a lot of makeup work to do. So what's the penalty if you don't do this right?
Well, I'm glad you asked. I-9 is one of those risks that is at the top of my list. The penalties per invalid I-9 can range from $272 to $2,700 per document. And there have been plenty of cases with large employers with six-figure plus penalties over the years. The reason you don't hear about it is because an I-9 audit is a little bit like lightning striking. There's many employers, and the audits are, limited to the ones they can do with their personnel. However, every staffing company that exists is whistling by the graveyard with their I-9s, because when the audit notice comes, you have 3 days to get ready, to have all your I-9s lined up, ready to go, and be examined line by line, bit by bit. And the typical number of mistakes found on an I-9 is quite large. If the people filling them out haven't been trained, there's a very good chance that something's going to be wrong. And all you need to do is Google common I-9 mistakes. That's all you need to do, and you will find lists of things. And the CIS also has a list which is fairly modest compared to the other ones you can find. The instructions for an I-9 form are 15 pages long.
Isn't that crazy? Because it's really a pretty short form, relatively speaking.
It is a short form, but there's 100 ways to mess it up.
Yeah, there really are. So what if agencies have been using the authorized representative technique? So even during the last 40 months when you could do the remote electronic document review, what if they've actually been using allowing the person completing the I-9 to have somebody act as an authorized representative, because I've heard this concept out there, to actually sign on behalf of it. And I know that there's been some of the digital onboarding tools will use this sort of work around the authorized representative. What if that's been going on? Will that suffice, or does anything have to be updated with that one?
Well, you presumably, when you do that, the person is remote from you and you're not going to be able to do it yourself.
Right.
So either the same authorized representative needs to update it, or another authorized representative, in which case, when you annotate, you will have to make some change. You'll have to show that it's a different authorized rep who did it. And it gets pretty technical pretty quickly. And a disclaimer, I'm not actually an immigration lawyer. I'm a staffing generalist.
Right.
So I'm going to put in the disclaimer now that all of this is pretty technical, and you should at a minimum study the information on the USCIS site about how to do this. Even better is to talk to your immigration lawyer or your employment lawyer who does this for a living, and make sure you're doing it right. Because the worst thing would be to go back and do it again, to spend the resources, right? And then it's wrong, and it's wrong.
Yeah.
So that when you're audited, even though you went back and did it, you're still fined because the form's not right.
Yeah. Yeah. That's a big one. And that's why compliance is ever so more important to one, not just get regular updates like yours, because yours keeps you in the know and it kind of points you in the right direction of what you should be focusing on to stay compliant, which I appreciate. But then even having other compliance partners out there, like, companies like Compliance Solutions that do this third-party independent auditing to make sure that everything is correct. So important to work with companies like that in today's kind of economic and regulatory climate. So
there are a number of companies, Dan, that will now do the full service for you, up to and including, finding you an authorized representative and making sure the form's filled out correctly. Of course, it costs.
Yeah.
However, it's a one-time cost.
Right.
And, nobody complains about having to pay for background checks. Right. This is similar, same thing. Get used to it. Because
that's true. That's a good analogy, Bill. I like that.
Because it is unbelievable to me how many of my smaller clients just were not aware of this. That's why I've written like 3 articles on it. And people keep calling me and saying, what? Wait, what?
So just to go a little bit further down to kind of analyze the work that needs to get done, this particular article, you alluded to existing versus terminated. And we obviously just covered that all of it has to be definitely done for existing employees. But what about the I-9s of the terminated employees that we can't do? Like, is there a best practice that we really need to be thinking about how to treat that? Is there anything we have to do, or can we just say they were terminated prior to August 30th, 2023, and no harm, no foul?
If you don't annotate that in this box, you'll probably be fined.
Okay.
For your terms. So I got this off the CIS website this morning. It's an example of what they want you to do. I don't know if you can read
I can see it. Yeah, that's good.
You see the handwriting in the box there?
Yep. Yeah, remote inspection completed on the state COVID-19 documents physically. Yeah, got it.
That's what they want you to do.
Okay.
And
wow.
For both the re-verifications and the terms, they want you to fill in that box. And in some cases, I don't know if you have a new verifier, I don't know if you need to do a whole new I-9 or not. That's a technical topic I haven't explored yet.
I might have to have one of our the employment lawyers that focus on this on the daily opine on that one.
But yeah, but it's probably, for the most part, it's annotating in that box, that additional information box, what you did. and who did it, initial it, all that stuff. But when you Google how to fill out an I-9 form, you'll be amazed at all the little tricks and traps. If you use E-Verify, there's different things you have to do.
That's a good point too. Is there any guidance on people that have been using E-Verify through this process? Are those people going to be compliant already because they utilize E-Verify, or is there something that they might have to do too?
Well, no, here's the crazy thing. E-Verify is not a substitute for I-9.
That's interesting because most people think it is. Why do you say that?
It's not.
What is E-Verify then?
It's icing on the cake, I guess.
Okay. That's interesting. So,
and another disclaimer, I don't make these rules. I just try to help people follow them.
I think that's the disclaimer, right? This is not legal advice, right? This is just legal awareness.
If you're using E-Verify and not doing I-9s, when they come in to audit you and you don't have any I-9s, you're going to pay a fine.
And one other thing I want to point out in this article, and then there's one other question that literally just came up recently that I want to squeeze into this interview. You do mention, I think this is just a good reminder. So before I mention this, do your homework, people. Train your people on how to do I-9s the right way. It's amazing to me how many issues still exist with filling out an I-9, particularly in the staffing industry, where we fill out I-9s in volume, in droves every single day, and yet it is still one of the biggest areas prone for error. So it is worth your weight in gold to professionally train your people, hire someone to do a training, whatever you got to do, but make sure every single person that's going to be filling out an I-9 for you knows exactly the right way to do it. And Bill's obviously shared some good feedback on how to figure that out. But there's another piece that I appreciate that you called it out. It was a great reminder that if someone worked less than 2 years, you need to retain the form for 3 years after the date you entered the first day of employment field. And if they work for more than 2 years, then you need to retain the form 1 year after the termination date. So I just thought it was nice that it was a good reminder to help people stay compliant with the I-9 piece.
Yeah, there's purge rules, which are a little tricky, but in all cases, it's going to be 3 years after the hire. But it's generally recommended by the experts to routinely, and that means quarterly, go through your I-9s and purge the ones that are purgeable under the law, because that reduces your audit exposure, in theory.
That's interesting. So if you're staying compliant with the purge laws and you're basically just getting rid of everything that you legally are not required to hang on to, then that's not able to be brought into an audit. But if you're not doing that, if you're not if you're just, let's just say a company that's been in business for 20 years has I-9s for every employee they've ever employed, and then they want to come in and audit, do they have the purview to look at all of those?
My understanding is they typically only audit for 2 years.
Okay.
But that they have the legal authority to go back 5.
Oof.
So being able to purge after 3 years from the date of hire does give you some protection, I understand, from the experts.
Okay.
But speaking of audits, it is highly recommended that employers of all types audit their I-9s and go through them. You are permitted to make corrections after the fact. What typically happens when an audit notice comes in is, and you got 3 days, is they start looking at these things and they start finding mistakes and they start frantically pulling all-nighters trying to fix them.
Yeah.
And you're allowed to do that as long as you document it.
Right.
But it is, if you're an employer of any size with a lot of mistakes, you're not going to get through them all. Another factor here is you really need to keep your I-9s in a separate location together, because when the audit comes, you don't want to be going through personnel files looking for them.
Yeah.
You won't even get that done in 3 days.
That's true. And auditors generally appreciate if you're organized,
Well, I'm not sure it's a requirement, but it's a de facto requirement. You got to have them out and ready when they show up. And
Staffing
or
is
if they're
not easy.
electronic, have them lined up electronically. And the electronic, record keeping of I-9s, there's plenty of rules about that too.
Yeah, and we're a bunch of crazies to be in this industry. But if I may bend your ear for just another minute, you just posted another article talking about, I guess, the opinion of the Supreme Court and something that directly relates to the employment industry, possibly around discrimination or whatnot. So can you talk a little bit about that recent post that you just put out?
Sure. This is the recent Supreme Court ruling on religious accommodation. That is, employers accommodating the religious preferences and needs of their employees. This has not really been a big issue historically, because the standard historically has been, if the burden on the employer is more than trivial, you don't have to accommodate. In other words, okay, you're required to make trivial accommodations, but not serious accommodations, unlike the Americans with Disabilities Act, where you're typically required to, if necessary, spend some money, right? Or lose some money to accommodate somebody.
Yeah.
Now, when you are in the staffing business and you have a thin margin, particularly in the industrial context, where guess where most of these disability accommodation claims arise? It's typically on the factory floor, on the warehouse floor, and you've got a $5 margin or something, and suddenly somebody needs all kinds of special accommodation. It's very tough for the staffing industry, and it gets even tougher. I'm still on disability. I'll get to religion in a minute. It gets even tougher when the client isn't willing to accommodate what they consider to be a temp who's not theirs. And so I have written many times about one of the most troubling problems staffing companies are having these days in the equal employment opportunity field. It's clients unwilling to accommodate disabilities. Guess who gets sued when this happens?
Everybody.
The staffing firm always gets sued.
Everybody.
And usually the client is joined, okay? But maybe you signed some crazy indemnity agreement because you didn't have somebody like me review the contract that says it's your problem, even though the client did the discriminating. All right. So that's a tough problem. There's things you can do to mitigate that risk. But in religion, accommodation, there was a duty to accommodate, but it was very thin, no problem. Nobody worried about it. Well, you're going to worry about it now, because the Supreme Court just entered a standard. They claimed it was a clarification, not a new rule, but it's a new rule that says the standard for accommodating religious preferences and needs is everything up to substantial expense. The only defense you have is that this would incur substantial expense. This is virtually the opposite of the former standard. In other words, and by the way, substantial is not defined.
Well, that was maybe my next question. You're reading my mind. Is like, what is substantial? I feel like that's a pretty subjective term.
Well, it's going to be interesting, because for a large organization with 10,000 employees, it might be $5,000. I don't know. For a smaller organization, it might be 500.
Yeah.
This is going to create lots of litigation that didn't exist before. Although I would suspect there's not as many desires for religious accommodation as there are for disability.
Sure.
But in this case that the Supreme Court ruled on, it was a mail carrier working for the U.S. Postal Service who said, I'm not going to work Sundays. And the Postal Service disciplined, I believe, terminated him. And he took it all the way to the Supreme Court. And the Supreme Court said, unless this causes substantial expense to the U.S. Postal Service, you will accommodate him.
What happened? Did he get his job back, or did they show like?
Well, no, the case was just decided 10 days ago.
Oh, okay.
And they remanded it to the lower court, and now they're going to have a trial on what substantial expense is and whether or not that threshold is being crossed. And that, as I said in my article, that basically means every one of these cases needs to be tried in court.
This is crazy.
If you're going to get a real answer. And of course, that's not going to happen. It's almost guaranteed that if somebody has any kind of colorable religious accommodation claim that the employer doesn't want to do, there's going to be a lawsuit and there's going to be a settlement, because the cost of trying it to figure out what's substantial or not is going to be
that cost is substantial.
Yeah. So basically, all these cases are going to be brought. I say all these cases. I don't know how many are going to be brought, but I predict more will be brought than have been brought in the past. Things like Sunday work, obviously, prayer time, things like that. It's going to be interesting.
Yeah, it will be. I will be, and I know that you'll keep us up to date with Staffing Legal News. So I'm like I said, I'm grateful for that. Bill, I thank you for your time today and providing some more insight on what's going on with the I-9 and the ending of the electronic document review and what agencies need to be doing to correct it and those important deadlines, and also sharing the most recent update hot off the presses for, legal or religious exemptions that employers might have to be thinking about. You mentioned one thing in here, and I'm going to circle back with you and bring you back on the show to talk about it. But you alluded to indemnification. And I know that one of the things that you do for your clients is contract review, and you help them make sure they're not over indemnifying and basically bringing all of the fault and guilt and responsibility onto themselves. Since you teased that, I'm going to follow back up with you and see if we can have you back on and talk about that specifically. But I'm grateful for your time here. Anyone listening, I will go get a subscription to Staffing Legal News. It is so good, so worth it. Bill, if anyone wants to follow up with you and talk more about maybe specific challenges they're facing and get your opinion, what's the best way for them to get a hold of you?
You can find my contact information on staffinglaw.com.
Awesome. And I'll get all those links on page so people can click and get right to you. Are you a LinkedIn guy? Are you on LinkedIn? If I were to put
I'm all over LinkedIn.
Okay.
I like to think.
I'll make sure that we get that link on there as well. So Bill, thank you so much for your time today, man. It is always a pleasure hearing your opinions on this, and we'll certainly have you back on to share more with our audience.
My pleasure, Dan. Thanks for having me.